Hi everyone, thanks for sticking around for the Wednesday lightning talks. I'm David Wishnick. I am an academic fellow at the University of Pennsylvania Law School, Center for Technology, Innovation, and Competition. Don't run out of the room because I said law school. I'm talking about RPKI, which is a technical topic, but it has some legal elements to it. So I'm presenting an update on some work that I've been doing with Christopher Yoo, who couldn't be here today. And we are funded by the National Science Foundation. You can see the award number down at the bottom if you want to go check out the details in the public record. So what I'm going to do today is just describe a little bit about our project, where we've been coming from, and then give an update on where things stand with potential legal barriers to RPKI adoption in North America. So, for those who don't know, I'll give a really brief background on RPKI. It is a two-sided framework to secure routing tables. And what people do is if they hold IP addresses, they can create certificates that identify authentic IP address origins. So it's origin validation, not route validation. Once you issue a route origin authorization, a ROA, other people who are running networks can then validate routes based on those ROAs and decide how to treat them in their routing table. So two-sided framework, signing and validation. Now, the last 12 months have been quite eventful for RPKI. Let's see. So, beginning in July, NTT began combining RPKI information with IRR data to improve some of their filtering. Some good things, some bad things. In August 2018, Amazon DNS was hijacked. Later in 2018, Cloudflare committed to RPKI, and they began developing their own route validator called Octo RPKI. And let's see, in February 2019, AT&T began filtering routes. Google is doing similar things. And over 100 networks have joined ISOC's Manners mutually agreed norms for routing security. So we're at perhaps something of an inflection point in terms of buy-in on RPKI in North America. On the other hand, if you look at some of the figures from the worldwide perspective, you can see that the North American region is not doing as well, especially as RIPE and APNIC. That's on both signing and validation. So on the signing side, this graph is not perfect. It's, but you can see the blue line represents ARIN in terms of percentage of declared IPv4 space covered by ROAs. Now, that blue line is well below RIPE and below LACNIC and below APNIC. But as you can see in the past few months, there's been a decided uptick in terms of ROA issuance. Now, the problem that may in fact be a bigger problem is that people who then issue those ROAs might want people who are doing validation to validate based on those ROAs. Unfortunately, in 2018, a researcher named Ben Cartwright-Cox found that 80% of people who are engaging in ROV at the time that he looked into it were omitting the ARIN TAL. That may have changed since then, but that's a disheartening number from 2018. So what's the problem? One hypothesis that was kicked around a couple of years ago at NANOG, in fact, was that there were some legal barriers that were specific to the North American region. And what Christopher Yoo and I have been doing over the past year and a half or so is looking into that hypothesis, trying to kick the tires. We interviewed a lot of you. We got a lot of feedback trying to piece together what are the legal barriers and how might they be addressed. So, you know, there were reports, and people specifically focused on an indemnification clause in ARIN's contract called the Relying Party Agreement, which is what people have to agree to if they're going to engage in validation using the ARIN Trust Anchor Locator. So that was the hypothesis. What did we do to figure out whether that was true or not? We analyzed a lot of legal materials, contracts, policies, court cases. We interviewed a lot of stakeholders, and we engaged with people in the ARIN and NANOG community over a number of meetings trying to really understand things. We made some presentations, and again, I really want to reiterate how helpful everybody was who we reached out to for interviews within this community. We also released a report in December 2018. You can read it at this annoyingly complex link, which will be posted on the NANOG website, or you can email me for a fresh copy. And then we presented at ARIN 43, and so one of the things that our report had is a bunch of recommendations for what the North American routing community might want to do to address some of the salient legal issues. And ARIN has been quite receptive to the report, and at ARIN 43 there was a discussion. Christopher Yoo, my colleague, presented, John Curran presented on the topic, and the upshot is that ARIN is committed to conducting a full review of their contractual policies having to do with RPKI, likely to conclude by the end of 2019. Commenters at ARIN 43 in Barbados encouraged swift action. And indeed, one commenter said, if you want to increase my fees, you're welcome to. I don't know if everybody agrees with that, but just reporting one person's view on that topic. But at any rate, the key takeaway here is that there is a lot of interest in this, and there's dialogue going on that ARIN is quite involved with, and as a member-driven community, you all should feel free to reach out to ARIN and to be a participant in this dialogue going forward. So that's the procedure of what's going on. What's the substance? I'm going to go through this at a very high level. You can read all 35 pages of our report if you want, or like the 3 executive summary pages, maybe that's more, that might be a little easier. But at any rate, the key high-level issues. The first one has to do with acceptance of the relying party agreement. Going into the past few months, there's been a difference between how you access the TAL for the other 4 RIRs and for ARIN. That's because in the US, in order to get a binding contract, you need to have some sort of manifestation of assent. Click a little box, or you see in your visual field something that says, there's a contract here. You're hereby aware, and you're going through our webpage, you'll be bound by this. That is not something that the other RIRs have demanded, but it's something that ARIN has felt necessary based on the US legal environment. So one of the key things that is perceived to be holding back adoption is that difference, which makes it hard to automate the download of the ARIN TAL. Also, there are some clauses in the RPA that people have suggested are holding back the organizations from participating in RPKI. One of those has to do with indemnification. So, those are the key issues. What did we recommend in our report? We really went through a couple of scenarios that we think ARIN should be considering right now. One of them is elimination of the RPA altogether. That would obviously allow software developers to automate the download of the ARIN TAL without any contract. There would be no contract anymore. Now, we think that's a reasonable path. We also think that there are other reasonable paths, one of which is to consider dropping the indemnification clause and replacing it or retaining what's known as an as-is disclaimer that would allocate liability in a way that's maybe less onerous on the user than the indemnification clause. There are lots of puts and takes to this topic. It's complex, and both paths are reasonable by our lights, but they fall out in different ways in terms of who's advantaged and who is able to do what they want with the ARIN TAL. Now, another idea we floated is the creation of a new nonprofit that would be in charge of distributing the ROAs and the materials you get through the ARIN TAL. Now that, I don't know whether that is gaining traction or not. It's maybe a little bit out there of a solution, but you could imagine an organization that doesn't have the other functions that ARIN has taking a different approach to how they view liability that they're trying to protect through contract. Lastly, we suggested that it would be useful to encourage people to integrate acceptance of the RPA into validator software rather than having to send people on their own to the ARIN website to get the TAL. Now, I'm happy to report that Rootinator 0.4.0 is doing that right now. And ARIN is open to anybody who wants to build software that automates, that puts it in the workflow for getting a routing validator software up and running, to put it in that, in very similarly to what you see in this workflow right here, which says, if you agree to the agreement, please run the command. Now, that's a lot easier and a lot quicker than having to go to the ARIN website and get things going that way. Not everybody's satisfied by that. It still is a roadblock of a sort in the process. But I think that it's great that ARIN has made that possible and that the team building Rootinator has put that into practice. So what are the other issues? Another issue is in the RPA, there is a clause called the prohibited conduct clause. It prohibits the distribution of machine-readable information about RPKI. Now, you can imagine a lot of really useful reasons why you might want to distribute machine-readable information about RPKI. Analysis for research. You might even want to use it for real-time routing and filtering, like NTT is combining RPKI information with IRR information. People might have creative ways of using this and wanting to do some machine-readable transfer of information in real time. My sense, and John can correct me if I'm wrong, is that ARIN is open to uses of this that are responsible and that don't impose safety concerns and risks on the use of RPKI information. So if you're interested in doing that kind of thing, I think it would be sensible to shoot an email to ARIN. One of the big takeaway, like the global takeaway from Christopher and my work over the past year and change, is that dialogue and reaching out to organizations that are here to support the community would move things forward. And so if you have gripes about legal things like that, good to get your team involved, maybe check in with the lawyers at your organization, reach out to ARIN and try to build some dialogue. I think that we're seeing progress because that dialogue is moving forward right now. So another recommendation we made is if you are buying anything that has any adjacency to routing, think about putting the use of RPKI in your procurement requirements. That would build a network effect to get signing and validation off the ground in North America. Lastly, publicize information about best practices, reach out to manners, learn how to do this. That is a way to get this thing off the ground. Legal issues might hold everybody up, but it's going to be tech deployment that gets RPKI going. And to that end, deployment of best practices. There are RFCs on this. Useful to do it, more important to do it right and to do it safely. So especially for failover. And solicit advice from people. And RIRs also should be following best practices and making disclosures about service levels. So engage, ARIN should be considering the RPA changes right now, and the ARIN community should really consider some of these recommendations and should be engaging in dialogue as this review that the ARIN board is undertaking is going on. And with that, I'd like to open it up for questions. If anybody has questions on this topic, happy to answer them and maybe engage in some dialogue right here.
Hi, my name is Ross. Can you explain what the relying party agreement is and why people would not want to agree to that?
Sure. I'm sorry that I didn't give a high-level description of the relying party agreement up front. So it is the agreement that binds people who are downloading the repository of ROAs and certificates and things like that through access to the TAL. I think John may have some close enough for rock and roll? Okay. Yeah, so it's the agreement that you have to enter into in order to gain access to the materials you get through the ARIN TAL. Now, people might not want to bind themselves to it because some people's organizations don't allow them to agree to indemnification clauses. If you encounter an indemnification clause, then you, as a person who's considering signing that contract, can't do it under your organization's rules. Other people may not know what's in it and may feel uncomfortable clicking through it. People may just not want to, on philosophical grounds, agree to terms and conditions on something like RPKI, which is supposed to have very widespread deployment. So there are all sorts of reasons. And you know, an organization like ARIN has to balance which of those they credit and which of those they don't. And people have to internally within their own organizations figure out what their policies are in terms of those types of agreements. And this is a big thing in open source as well. Is that helpful?
Yeah, thank you.
Yeah, sure.
Hi, I'm Scott. Do these same restrictions apply, and are these same problems evident when the RPKI user wants to run their own certificate authority? Is it still relevant what you're talking about?
So I think that that would be covered by the registration services agreement that ARIN has. And that also has very similar terms, but everybody who is running a network and who's a member of ARIN has already signed on to that contract. So rubber doesn't meet the road in the same way on
Okay,
that side.
thank you.
I can speak to that. Rob Seastrom, I'm on the ARIN Advisory Council. I'm speaking only for myself here, but I'm going to limit my commentary to the technical aspects of this. There are two halves of RPKI, and you need to separate them in your mind. The Registration Services Agreement is coupled with your ability to issue ROAs, and whether you run your own, your self-hosted, or whether you do the hosted validator with ARIN, is orthogonal to the question of validating the other people's ROAs. And the discussion here has been centered around the relying party agreement, which you need to get the TAL from ARIN, which is, it's like the trust anchor that's in your web browsers that says, I believe semantic certs, or I believe Komodo, or whatever. It's what allows you to validate other people's announcements. So split that into two halves. Thank you.
Okay. Thanks, Rob. And
All right.
thank you, David.
Thank you.